All right, Mr. Chair, we are live.
Okay.
Would you like me to take roll?
Thank you very much. This is my name is Senator John Edwards. I chair this committee. Delegate Price is the vice chair, and I would like to remind everybody to turn off to mute their microphones when they're not speaking. And would the clerk call the roll?
Senator Serval, Delegate Bagby, Delegate Mullen,
Present.
Delegate Samira, Ms. Kelly. I think I see her here in our audience.
Yes, here.
Pardon me. Thank you, Ms. Kelly. Mr. Abrenio.
Present.
Commissioner Land, Commissioner Oliver, Commissioner Storin, represented today by Chief Deputy Commissioner Berger.
Present.
Delegate Price.
I know she's here.
Yep, I'm here. Sorry.
And Senator Edwards.
Here.
Mr. Chair, you have a quorum.
Okay, good. Thank you all very much. This is the first meeting of the year 2021. Moving on to 2022, hard to believe it. Since our last meeting, which was November the 16th, 2020, this commission has been continued. I'd like to ask Anna Moyer of the DLS to tell us where we are with the subcommittee.
Thank you, Mr. Chair. I'm just going to provide a quick overview of this joint subcommittee and its work before we get started. The Joint Subcommittee to study barrier crimes and criminal history records checks was continued through Senate Joint Resolution number 285 in the 2021 special session. The resolution directs the Joint Subcommittee to complete its meetings by November 30th, 2021, and submit an executive summary of the Joint Subcommittee's findings and recommendations no later than the first day of the 2022 regular session. Senator Edwards serves as the chair of the Joint Subcommittee and Delegate Price serves as the vice chair. The Joint Subcommittee is limited to no more than 4 meetings during the 2021 interim. In the final meeting of 2020, the Joint Subcommittee directed the Department of Health, the Department of Social Services, and the Department of Behavioral Health and Developmental Services to look into over the winter and report back to the Joint Subcommittee on the following questions. 1, what should and should not be a barrier crime? 2, whether there should be a time limit following conviction when a crime is no longer a barrier crime and what such time limit would be. 3, whether there should be an exceptions, waiver, or appeals process and what that would look like. 4, demographic data on individuals for whom a background check is completed and for whom a criminal conviction is a barrier to employment, licensure, etc. 5, recidivism rates of barrier crimes. 6, information on what has been done in other states regarding barrier crimes and criminal history records checks. And 7, if there should be tiered levels of barrier crimes and what that might look like in the code. We will begin by hearing those presentations that will help to guide the work of the Joint Subcommittee this year. We will then have a public comment period where the public will have the opportunity to say whatever they would like related to barrier crimes and the Joint Subcommittee's work, and the chair may wish to limit time per speaker. Leftover time will be used for member discussion and directions to staff. Mr. Chair, that completes my remarks.
Okay, thank you. Gina Berger, the Chief Deputy Commissioner of the Department of Social Services, will give us a presentation on barrier crimes from her perspective. Thank you very much, Gina.
Good morning, Mr. Chair. I'm trying to pull up my slides. Are you all seeing my presentation?
Yes.
Great. Great. Let me see. From the beginning. Okay. So my colleagues and I at the Department of Health and the Department of Behavioral Health and Developmental Services actually met several times since the last committee's meeting. And what we did, we hoped that this would be helpful for you to be able to look across at some of the questions that you ask and be able to tell what the current state is in our various areas that we oversee. And so both of my colleagues at BDH and at the Department of Behavioral Health and Developmental Services are going to chime in on this first slide with me so that we can walk you through sort of a crosswalk of what this looks like across our different agencies and programs. So I'll take the middle one, which is DSS. So we do have a number of areas where we have oversight of barrier crimes and background checks. Those are in the areas of foster and adoptive parents and approving those, child and adult day programs, employment at child and adult day programs, and then also assisted living facilities. So those are the areas where we have statutory rules around barrier crimes. And I will go into a little bit detail on the next several categories and what that looks like. But yes, there are also already time limits that exist in some of these areas. There are tiered levels as well. And we do have a number of federal requirements that we have to comply with at a minimum as well. And then we do currently have some waivers or exceptions. And again, I'll go into greater detail on that in a moment. And unfortunately, we don't have demographic data. And I'll talk a little bit about what we hear anecdotally from folks at our local departments and local child placing agency efforts. So with that, I will turn it over to DBHDS.
Thank you, Gina. Good morning, Chairman. So DBHDS does have oversight of the barrier crime code sections for us, and those groups that we have oversight are our state facilities, the community service boards, and the private providers that we license. And also child residential. We have those as well. We do have several time limits depending on what type of crime it is. There's a 5-year and a 10-year, and we'll get into that in our presentation. We do not have tiered levels, and we'll talk a little bit more about all of these categories, just like Ms. Berger said. We do not have any federal requirements, so all of our barrier crimes are from the state level. We do have a screening process, so an exception for certain crimes and certain timeframes. And then again, we do not have the demographic data, unfortunately, either, based on the information we can gather with our systems. With that, I'll turn it over to VDH.
Let me ask you a question.
Yes, sir.
We're talking Stacy Pendleton, not Allison Land, but you're the deputy?
I'm the Chief Human Resources Officer here at DBHDS.
Okay. Now, as I understand it, there are no federal time limits. Is that right?
Correct.
Okay. And the only time limits are here in Virginia.
For us, because we don't have federal requirements, they all are state level. Correct.
How many states have time limits? Do you know?
I do not know that answer off the top of my head. We certainly can get that information.
Okay, be helpful. Okay. All right, thank you. Next is the Department of Health. Is that right?
Yes, that's correct, Mr. Chairman. Good morning. I'm Rebecca Allen. I'm here to speak on VDH's behalf. So for us, like the other agencies, we do have oversight for barrier crimes enforcement. For our programs, this would only apply to nursing homes, home care and home health, and hospice. Hospitals are not part of the barrier crimes piece. They do not have a barrier crimes requirement put on them. Like the other agencies, we do have some time limits in place for misdemeanors. But for everything else, it's pretty much a no across the board. There are no tiered levels of barrier crimes. Like DBHDS, there are no federal requirements. So in the absence of state barrier crime requirements, there would be none. There is no waiver or exception process. And we do not have demographic data available to share with this group, which of course, like everyone else, we will go into more detail when it's time for VDH to give its full presentation.
Okay, now you are Rebecca, what's your last name?
Allen, A-L-L-E-N.
Okay, because Dr. Oliver is not available, right? And what is your title?
My title is Senior Policy Analyst at the Office of Licensure and Certification.
Mr. Chair?
Yes.
This is Dr. Oliver from VDH. Both I and Commissioner Land are on the committee, but our reports were given by the folks who are the most knowledgeable in that area.
Okay, Dr. Oliver, thanks so much.
Thank you, sir.
Appreciate it. Okay. Thank you very much. We want to make sure everybody knows who's who. Okay. Next.
Okay, so wanted to go a little bit more in detail in terms of the questions that you ask us for each of our agencies. So the first question you asked was, what should and should not be a barrier crime? Obviously, you know, this is a policy decision for this joint subcommittee and the General Assembly to make. But at a minimum, we want to just say that Department of Social Services does have federal laws governing barrier crimes in our program areas. We submitted a document to you that has a lot more narrative in answering the questions that you ask, and also has links that you can go to find what are the federal versus state barrier crimes. So there's two areas where we have federal requirements. So those child welfare, meaning who can be a foster and adoptive parent, and then also for child care programs. So based on our staff's research, Virginia's statute for barrier crimes is much more restrictive than federal law in both the areas of approving prospective foster and adoptive parents and employment in a child care program. At the first meeting, several of you voiced support for focusing on barrier crimes, particularly where we're talking about prospective foster parents. And we'd also suggest that you might want to look closely at specifically barrier crimes for relatives and fictive kin who are seeking to be approved as foster parents. So this is an area where both the state and federal direction and the best practice is to keep children at risk of being removed from their homes with a relative or fictive kin. In addition, there are racial disparities that exist in Virginia's foster care system. Black and African American children in foster care are more likely to age out of foster care without a permanent caregiver. And because we know that the data also tells us that Black and African American Virginians are disproportionately represented in those convicted and incarcerated, Virginia's barrier crime statute is considered to be an impediment for placing Black and African American children with their relatives and fictive kin. So this could provide, you know, a new avenue to create more permanency for children in Virginia. So that's one area that we'd suggest you look closely at, because we are much more restrictive, particularly in foster care, and have a whole list of misdemeanors that also count, and the federal government only has felonies. So you asked about time limits. So federal law already incorporates time limits for certain crimes. So under federal law, if a prospective foster or adoptive parent has a felony conviction for physical assault or battery, and so long as the victim of such crime was an adult and it was not domestic violence related or a drug related offense, the conviction would not be considered a barrier crime so long as the felony was not committed in the last 5 years. However, Virginia's laws are much more restrictive, requiring the period of lapsed time to be 10 or 20 years in some cases. In addition, many of the time limits must also be accompanied by other conditions, such as requiring that one have their rights restored by the governor. You ask about exceptions, waivers, and an appeals process. The Code of Virginia does currently have provisions for some exceptions and waivers to barrier crime convictions. These exceptions and waivers vary between programs with specific circumstances and do not apply across the board to all program types. The federal law also allows for exceptions and waivers in certain circumstances in programs. So in Virginia, let me go back. In Virginia, in terms of exceptions, the Code of Virginia allows for exceptions for a child placing agency to approve a foster or adoptive parent for certain convictions when a specific time period has elapsed and the person has met circumstances. For child care programs, the Code of Virginia allows a child daycare center to hire a person who has been convicted of not more than one misdemeanor offense or any substantially similar offense under the laws of another jurisdiction if 10 years have elapsed following that conviction unless the person committed such offense while employed in a child daycare center or the object of the offense was a minor. Assisted living facilities and adult daycare centers can hire individuals with one misdemeanor barrier crime conviction not involving abuse or neglect or any substantially similar offense under the laws of another jurisdiction if 5 years have elapsed following the conviction. I know you guys were interested in some of these areas, what other states are doing. So we particularly looked at sort of our border states, thinking about employment and recruitment across state lines. And in Kentucky, a rehabilitative program will allow certain individuals to be employed with a disqualifying offense after a certain period of time and or a home study has been completed. Consideration is also given to those with expunged records or dismissed cases. In terms of waivers, under federal law, individuals with felony drug-related offenses are eligible for a waiver review for those seeking to work in a child care program, but the state statute does not provide this option. So that's one area where you differ significantly with the federal law. Section 63.2-1723 of the Code of Virginia gives the DSS Commissioner authority to grant a waiver to an adult household member of a family day home. So that's a different type of child care program, right? This is where children are, the business is operating out of a home. With only one misdemeanor conviction of assault and battery or assault and battery of a family household member, as long as certain criteria are met and the household member is not employed by the family day home. The waiver request must include information related to each conviction, documentation on circumstances of the crime, description of what the individual has completed to improve character and reputation, such as treatment or diversion programs, and 4 letters of reference. Federal law also allows for waivers to be granted for relatives and fictive kin seeking to become foster parents. However, federal law does not permit waivers for all other types of foster homes. So again, that's one reason why we thought you guys might want to look more closely at that, because the federal government does for relatives and fictive kin caregivers. Under Virginia Code, no waivers are available for those seeking employment in assisted living facilities, adult daycare centers, child care programs, with the exception of those family day homes, and children's residential facilities. If the General Assembly were to change the statute, VDSS could institute a waiver process for certain barrier crimes as long as the statute complied with the federal law. One option the Joint Subcommittee may wish to consider is to expand the waiver process to allow the DSS Commissioner authority to grant a waiver to all DSS programs when an individual has one misdemeanor barrier crime conviction, provided that 5 years have elapsed following the conviction, and the conviction does not involve children, does not involve vulnerable adults, and does not include sexual offenses. The waiver could be transferable to another agency within 12 months of the waiver determination date. After 12 months, the individual would need to request a new waiver when moving to another agency. And when looking at this, it looks like West Virginia has a similar process for this. We mentioned demographic data. We do not have demographic data. However, I can tell you in terms of the foster care realm, anecdotally, we hear a lot from our local programs and child placing agencies that they often, in the process of trying to identify a relative or fictive kin caregiver, will ask questions of the individual that they're screening, and it will come out in that process that the individual has a conviction. And so they don't even go through the process of the background check and all that, because they know it's already a barrier crime. So they tell us anecdotally that, yes, this is a barrier to finding more relatives and fictive kin caregivers. And then we included in the document that we submitted for you information on barrier crimes and background check requirements for prospective foster, adoptive, and kinship caregivers in each state. This data we found at the national level is from September 2018. Just keep that in mind. And then our staff also looked at 10 other states to compare employment and child care programs and what barrier crimes are on other states' list. And by far, Virginia's list is far more extensive than other states' barrier crimes list. Most states have more exceptions, waivers, or review processes that allow individuals with prohibited convictions to be considered for employment or approval. We sent in a spreadsheet that has barrier crimes national research for more details on that as well. And then you asked about tiered levels. If the General Assembly were to change the statute, we could implement time limits for certain barrier crimes or certain tiered levels. And in particular for foster and adoptive parents, we ask you to take a look at that, possibly being violent felonies, crimes involving a minor, domestic related crimes, drug related crimes, and misdemeanors in terms of those tiered levels. And that is my last slide.
Okay, any questions? One question I have is with regard, the federal government does allow waivers, is that right, in certain circumstances?
Yes, but our state statute prohibits that. Yeah, right.
And I understand by far Virginia's list is more extensive than any other state's barrier crime list. Is that right?
Yes, and in particular, Mr. Chair, when it comes to misdemeanors, so most of the federal rules do not include misdemeanors as barrier crimes unless they involve a minor and some of those other exceptions. But really, our state statute is more restrictive because we have a whole list of misdemeanors that are also included.
Yeah. Let me give you an example that I had probably 15 or so years ago as a lawyer. There was a daycare center in Roanoke, a very popular daycare center, that wanted to hire or elect a chairman of the board in his early 50s. And he actually had a private before, when he was early 50s, he and his brother got in a fight and he got convicted of assault and battery misdemeanors. He was prohibited from even being on the board, even though he didn't have any direct contact with children permanently. Now, things have changed a little bit since then, but still, and I remember writing the Department of Social Services. It says we have no waiver system, no, he just simply couldn't have the job that everybody who worked in the daycare center wanted him to have. They had elected him chairman of the board. And I thought that was outrageous. And since then, we've had a number of many Republicans put in bills to give exceptions, and all those got killed as well. So right now, you got too many people who are barred for life from doing a good job. And understand from what you were saying too, with regard to DSS, there are two problems. One is there's a shortage of people to do some of this work, and they would be people who would have life experiences that could be very helpful. And at the same time, the other side of that, by barring people from getting certain kind of jobs, it's a heavy burden on the welfare system in different categories. So for that reason, I hope we can make some serious changes here. So anybody else have any questions or comments?
Yes, Mr. Chair, this is Delegate Price. I did have a question. So I am hearing the difference in the number of restrictions that we have than other states. And so what I just want to complete the thought by asking the question, is there any proof that those extra restrictions are making things quote unquote safer, or is there any data supporting that that's what's needed? If it sounds like it's actually hindering some of the services that we need and some of the folks to step up. So I just wanted to complete the thought by also asking, is there any data that shows that there would be any negative repercussions for changing it?
Good question.
Yeah, thank you for that question, Delegate Price. And I can get you hopefully we can look into whether other states have any data on, any kind of safety measures. But I will tell you that we, in terms of placing children with relatives and fictive caregivers, we are way behind the rest of the states in the nation. And so I do think that this allows them to do a better job. And as the chairman said, a lot of these relatives and fictive caregivers would be a permanent home. And it's really, preventing us from placing them with the best person in the interest of their best interest. So I will look into whether there's any data that indicates differently, but.
Right. And thank you for that, because what I think that we need to do is start shifting to exactly what you're saying, starting to define safety in a more comprehensive way. And by having kids staying with their family or with people that they know and love, that is a part of a safer community. And so, just healthy and safety and really getting towards that, seeing what the barriers are. So thank you for that.
Okay. Any further questions? I will go now on to the Department of Behavioral Health and Developmental Services. Yes, Stacy Pendleton. Yes, sir. Yeah, Delegate Mullen.
Thank you, Mr. Chair. Gina, one quick question, if I may. I honestly was pretty appalled the fact that there are many circumstances in which there is almost no right of an appeal at all. My circumstance, and I know that Chair Edwards and the other lawyers who are on here, I'm just used to a right of appeal for everything. And so my request of you is, as we're going forward, is what are the appellate rights looking like in other states? And if we are going to have a universal right of appeal, to what body should that be? My guess is usually it would be the circuit court, but I don't know if it should be an administrative body. It seems kind of haphazardly what crimes have an appellate right and which ones don't. But it does seem to me like there should be a much more broad right of appeal.
Let me follow up on that. I agree with you, Delegate Mullen. I would hope it would be a simple administrative appeal that an individual could do without getting a lawyer, going to circuit court and all that. That's laborious. And I think other states can do that too, if I'm not mistaken. Is that right?
Yeah, I will look and get you all sort of a chart of what other states do. But when we looked at this, it was typically like the commissioner of the department that had the authority to grant waivers, exceptions, and it could also be, I would think, the Board of Social Services if you needed an administrative body.
That sounds even better. Thank you, Mr. Chair.
That's good. Okay, any further questions? All right, Stacy Pendleton, Chief Human Resources Officer for the Department of Behavioral Health and Developmental Services. That's a handful to say.
Yeah. Yes, sir. Good morning, Chairman. I will bring up my presentation here. Let me see if I could do that. Are you all seeing that? The presentation? All right, let me see if I can get it to. All right, still seeing that? Just want to make sure. All right, good morning, Chairman and committee members. We are going to go through very similar setup that Ms. Berger did for Department of Social Services. I would start out by just reminding you that we do look at barrier crimes for applicants for employment, but we also have sponsored residential service providers. So those providers, any other adult living in their home, and anyone employed by that sponsored residential. So it's a little bit more expanded for that program outside of just applicants. So there are some family members and others who are impacted by the barrier crimes. So that first question is, what should or should not be a barrier crime? And we would agree that this is really a policy decision for the commission to decide. However, we do have some thoughts about the areas that really impact our applicants are the drug-related crimes and misdemeanors. So those are two areas that we could certainly look at. Many of these applicants, Senator Edwards, you've mentioned this, have lived experience or firsthand experience with mental health or substance use challenges, which really could be invaluable to the work that we do. Many of these applicants actually have gone on, earned degrees, they have licenses and certifications, and they can't always use those credentials for our system. We do have 176 barrier crimes that directly impact our applicant pool, our workforce. And there are several crimes that we rarely see ever even come up that are on that list. And we can certainly get that information to you all as you move forward. And again, we mentioned before, we do not have any federal barrier crime regulations that we have to follow. This is all Virginia implemented barrier crimes. The next area was the time limits following the conviction. So we do actually use both the 5-year and a 10-year time limit. And two examples here are for felony possession of controlled substances. If there's been 5 years from the date of conviction and no longer on probation, then an applicant could be eligible. Misdemeanor possession is not a barrier crime. So for this one, we're just looking at the felony possession. And then a misdemeanor for assault and battery or assault and battery against a family member. A provider can employ someone who has had only one as long as it's been 10 years. So if it's been less than 10 years, they would not be eligible. And if they've got more than one on their background check, then they're not eligible. So there's some limiting factors there. So exceptions, waivers, or appeals process. So we do have what we consider a screening process. And there are 26 of those 176 crimes that are barriers that if you have one of those on your background check, if you meet certain eligibility requirements, you can go through a screening process and then become eligible to work. You must have been 5 or more years. So again, here's where 5 years comes in since the convictions. The charge must be directly related to substance abuse or mental illness. Completion of any prison or jail time. You cannot be under probation or parole. You can have no other pending charges, and you will have paid all of your fines. This is not a mandatory process, but it is permissive. So the provider, CSB, the facility can make that decision if they would like to go through that process with that applicant. They are screened by a licensed behavioral health provider, and we have a whole nother process that defines what those screeners, their credentials, what they need to have in order to be a provider of that service, as well as what they have to go, what the process is to do that screening. The screening is really only for if you are going to work in an adult substance use or treatment or mental health program. It is not for any developmental services, the sponsored residential, it's not applicable to that. And then once the provider gets this information, they can decide whether they want to hire that applicant or not. So that is for only those, for 26 crimes. Like social services, we do not have demographic data specifically our systems are not capturing that information. But what we have here is over the last 3, 4, 5 years, the number of barrier crimes and kind of a list of who is being excluded because of these barrier crimes. So assault and battery is one of our top ones that knocks people out. And again, that is many of these, their convictions were more than 10 years ago. However, they have more than one. So that then becomes a barrier. And this adds up to about 1,100 folks who are not eligible because of barrier crimes. We do not have data on recidivism for these barrier crimes. However, the data from the Bureau of Justice Statistics does indicate that it does decline year after year. So the further out you get, the less likely you are to be rearrested. So that data is presented here. The other states' approaches to barrier crimes. So we did speak a little bit about Illinois. Senator Edwards, you were talking about that early on. They do have a list of barrier crimes in their statute like we do. However, they do allow for a waiver or reconsideration of any crime. So they do have a process to go through that. And some states, Nevada, Alaska, they list it by length for disqualification. Some may be permanent barrier, but others are going to be anywhere between 3 and 10 years. And then Florida lists their barrier crimes by professional license, and we do not have ours listed out that way. So that is another way that we could look at this, and that the profession, each professional board could be looking at that as well. And you all asked about tiered levels of barrier crime. So a couple of approaches that we have looked at could be misdemeanor versus felony, drug-related crimes versus other crimes. We do have some of our barriers are just felonies, and some are both misdemeanors and felonies. The different time limits, we could expand on that. If someone is free of probation and parole, that could be a shorter time frame. And then you could put the appeals process in for felonies and then have a time limit for misdemeanors. So there are several different approaches that we have looked at. And I believe that is the end of our presentation. So any questions there that you all have for me?
Any questions for Stacy Pendleton?
Yes, Mr. Chair.
Yeah.
Delegate Price. Yeah.
Yeah.
So I just wanted to make sure that that I was hearing correctly. So if the fees and the fines are included, we're saying that you can't get this job until after you've paid money that you probably can't pay because you can't get the jobs. So is that something that we could look at, kind of tinkering with to see what would open up to break the cycles is what I'm trying to look at.
Yes, ma'am. I think that is definitely something that we can, research and look into.
Okay, thank you.
I would note that this year we got rid of the requirement to pay your fines and costs in order to drive your car. And so that's, in fact, the federal judge Moon in Lynch, I think Charlottesville, had a ruling to that effect that it was unconstitutional to require people to pay their fines and costs because it's discriminating against the poor. So that's something we'd certainly want to do. Delegate Mullen?
Thank you, Mr. Chair. Ms. Pendleton, you had a slide, which I can't pull up right now, but I think it was like your third slide, listing all of the drug-related offenses that were barriers to people being able to provide counseling for those who are dealing with drug-related issues. I think it was your third or fourth slide.
Was it the demographic data that we had the different, what the numbers were for each?
I believe it was.
Certainly, I can pull that back up here. Sorry, I got out of that. Let me go back to that real quick.
Just because I found that very informative.
Is this the slide you're speaking to?
So the reason that I was that and a couple of them immediately prior, the reason that I'm only bringing this up out of personal experience in the criminal justice system. What I've seen is that the people who are best able to help others who are going through addiction are those who have experienced it themselves. And if we are putting up arbitrary barriers like a 5-year cap before someone can be considered for these kinds of jobs, it seems like we are not allowing those who are most capable of helping others get out of the vicious cycle of addiction, be the advocates necessary for that. And so that's not really a question, it's more of a statement, but I'm looking at some of the requirements that we in the General Assembly have put in here and thinking that those are not reflective of the reality that I'm seeing in our court system and in our communities, at least here on the peninsula, for those particularly who are suffering from opiate addictions, which is the people who are the best advocates and the best guides for those who are suffering are those who've gotten to the other side. But that's more a statement than a question.
Correct. And we have really seen that actually in our peer support initiatives that we have, that this really bumps right up against those barriers and the time limits when you're trying to really enhance that pool of applicants and peers to help. So I agree. I hear you.
Can I ask a question?
Yeah, Delegate Mullen.
Thank you, Mr. Chair. I believe you said there are no federal requirements on that. Is that correct?
Correct. We do not have federal requirements.
So we have a free hand to do whatever we wish on the state level.
Yes.
Thank you.
Yeah, it kind of reminds me a little bit of the Alcoholics Anonymous. People who've had this addiction, often the best people to help other people with a similar addiction. I've seen this repeatedly. Opioids is a good example as well. Yeah. Okay. Any further questions? All right, we'll move over to the Department of Health. Rebecca Allen, Senior Policy Analyst, and Dr. Oliver is also with us, Commissioner Oliver. Rebecca, go ahead.
Thank you, Mr. Chairman. If you'll give me one moment, I will share my presentation. Does everyone see the slide deck, or do they see the speaker view?
There we go.
Oh.
Sorry, are you seeing this slide presentation or my speaker view? I just want to make sure that I'm...
We can see the speaker view, I think.
All right, one second.
Now we're good.
All right, thank you. Zoom's always a little funny in how it throws it up on the screen for me. So thank you again. My name is Rebecca Allen. I'm the Senior Policy Analyst at the Office of Licensure and Certification, and I'm going to be speaking to barrier crimes to employment in licensed medical care facilities. You've already seen this chart, but just as a reminder, the licensed medical care facilities we're talking about today are nursing homes, the home health agencies and home care organizations, and hospice. Not hospitals. They do not have any barrier crimes requirements put on. So we're only talking about these specific settings. So with the same set of questions that we received to the question as to whether or what should or should not be a barrier crime. As my peers at DSS and DBHDS have already stated, this really is a policy decision for the General Assembly to make. Like DBHDS, there are no federal prohibitions on employment at medical care facilities. There are no barrier crimes. So in the absence of any state requirements, there would be no barrier crimes to employment. For VDH, the barrier crimes that we have that we have to, enforce as barriers to employment. None of them are controlled substance crimes. Just the mere possession or intent to distribute. None of that would be a barrier crime for our licensure programs. I believe there is one crime that is if you possess a firearm in addition to possessing a controlled substance, that would be a barrier crime. But the possession of the controlled substance alone is not a barrier crime for us. In terms of what should and shouldn't be a barrier crime, the one thing that our staff noticed when we were going through the list of barrier crimes that we have, which is I think slightly more than 140 crimes. One thing that we did notice, and we weren't sure if it was a deliberate choice by the General Assembly or an inadvertent one, since the crime is relatively new. Section 18.2-51.7, which is the crime of female genital mutilation. It's the only crime in Article 4 of Chapter 4 of Title 18.2, which is your assault and bodily woundings chapter. That's the only crime in that article that's not included in the barrier crimes list. It is a crime that can only be perpetrated against a minor, and it's arguably of comparable seriousness to the other crimes, barrier crimes that VDH has for its licensing program. So we just wanted to highlight that as the one crime that we found left out. It's a relatively new one. I believe it was added to the Code of Virginia in 2017 or 2018. So just wanted to highlight that we noticed that and wanted to bring it to your attention. For time limits on barrier crimes, again, policy decision of the General Assembly. Currently, there is a 5-year time limit for single misdemeanors not involving abuse and neglect. There are no time limits on felony convictions of any kind. In other words, they are a permanent disqualifier for employment in the licensed medical care facilities that I identified. Some states, and I'll get into a little bit more detail about what other jurisdictions are requiring, they do set time limits by either category, so crimes against persons, crimes against property, or by severity, which usually is by felony or misdemeanor. In addition to that, some also build in flexibility about waiving some or all of the time limits. So some states would allow waivers for the misdemeanor crimes. Some would allow waivers of any time limit. It really just depends on the jurisdiction. For the exceptions, waivers, and appeals process, there is a statutory exception. It's non-discretionary. So if a licensed medical care facility wants to hire someone and they meet the criteria that's listed here, that they were convicted of a misdemeanor, it does not involve abuse, neglect, 5 years have elapsed since the conviction, they're eligible to hire. There's nothing Virginia Department of Health can say to stop that hiring process. It's non-discretionary. There's no variance or exception or waiver or appeal process built into the statute. So because there's not that in statute, we can't put that into regulation. So if they don't meet the criteria that's displayed here on this slide, there's nothing that the Department of Health or the State Health Commissioner can do. There is, and we pointed this out at the prior presentation that we had given, I believe in November of last year. It has been the anecdotal observation of our field staff when they're out doing inspections of these facilities that because of the lack of flexibility, the lack of discretion, we do find that in areas where there is a high patient or client demand and low workforce availability, that licensed medical care facilities will go ahead and hire folks who don't meet the criteria for the exception because they are so strapped for staff in order to meet the needs of patients and clients. And they basically are rolling the dice to see whether or not they'll get caught by doing that. So there's no flexibility around workforce demand. There's no flexibility at all for any sort of public health challenges that arise. And certainly rural areas when it comes to workforce demand are where we see the largest problems and the more likely incidents of non-compliance with hiring someone who has a barrier crime on their record. For demographic data and recidivism rates, unfortunately, the Virginia Department of Health does not have data that it can share on this because we do not perform background checks. We are not facilitating or acting as an intermediary for these facilities when they're doing these checks. So we don't have any data to offer, unfortunately. When we are doing compliance checks, our staff are going out into the field, going to the facilities themselves, and doing of the personnel files, they pull a random selection of them just to check to see if the personnel file is complete and if it's in compliance, because there's more requirements than just having a criminal background check for the personnel file. So they're checking for all the elements, one of which is having that criminal background check. So because that's how we check compliance, we do not have data to share on this point. Other states' requirements. So we took a more global view. We tried to do our best to do a 50-state survey. It's because every state does its licensing a little bit differently for nursing homes, home care, and hospice. What we would consider, for example, a nursing home here in Virginia may not be called that in other states. So we try to do our best to smooth it out as best we could. But the majority of states, they do have disqualifying barrier crimes for these programs. And we broadly group them in violent crimes against persons, sexual crimes against persons, crimes against the vulnerable. So that's going to be people with disabilities, minors, incapacitated adults, crimes against property, and crimes involving a controlled substance. In Virginia, again, that's not a barrier crime for us. Majority of states specifically list crimes rather than categories of crimes, which is what Virginia's model currently is to have specific statutes called out as either any felony conviction of X section or any conviction under X section. A majority of states do include felony and misdemeanor convictions, but there is a wide variability in what the disqualification time periods can be. The most severe crimes tend to be permanent disqualifications. For example, homicide tends to be a permanent disqualification. But the levels of disqualification time periods can vary anywhere from 1 to 10 years. And again, it's really hard to pin down specific patterns just because of the wide variability that we are seeing and what other jurisdictions are doing. As to the tiering of barrier crimes, again, that's going to be a policy decision we feel for the General Assembly to make, but we did want to draw your attention to the fact that the Centers for Medicare and Medicaid Services did examine this issue in 2012 in the long-term care setting. So not the full setting that we have here in Virginia for home health and hospice, but they did at least look at this issue because, as previously mentioned, there is no federal requirements, and this work group that CMS convened was supposed to look at what options are out there and what option do we want to go with if we don't want to stick with the status quo. As you can tell, here in 2021, they obviously have stuck with the status quo to date, and none of the options listed here have been implemented. But they did come up with 3 options displayed here on the screen, and I'd be more than happy to share the final work group's report on it. And this is how they called them: preliminary option 1, 2, and then consolidated option. So preliminary option 1 was a 3-tier based system on crime severity with disqualification periods for each tier. And there could be a waiver or variance. Someone could initiate a request for a variance or waiver at any time, even though they were still within the disqualification period. And it only addressed felony convictions. This option would have allowed states to choose whether or not to include misdemeanors. Preliminary option 2 would have been general categories of disqualifying convictions with minimum disqualification time periods per category. This one would have only allowed for waivers or variances to be processed after the disqualification period had passed. And the consolidated option, it takes the general categories of disqualifying convictions and combined it with the ability to ask for a variance or waiver at any time. And for all 3 of them, they had the ability they enumerated specific rehabilitation factors that should be taken into consideration whenever the variance or waiver process was taking place. And the factors could be anywhere from 4 factor, I think, up to 7 or 8 factors, depending on which option that they went with. But I did want to draw the attention of this group to the fact that CMS has looked at the issue and had come up with a tiering system based on its 50-state survey of what other jurisdictions were already doing. So with that, I believe that is the last of my slides. I did include in the back here selected slides from the prior presentation for your reference if you'd like to flip through them at a later date.
Any questions? I have a question, Rebecca.
Yes, Mr. Chairman.
My understanding, the recommendations are that there'd be a waiver in every case. Is that right?
The options that we had presented were not specific recommendations. It was just pointing out that CMS had looked at the issue and had come up with a couple of different options. I don't believe, and I will double check that, I don't believe any crime that they had listed was a permanent disqualification, but when you could ask for that variance or waiver is what was different between the options. Some of them you had to wait whatever the waiting period was before you could ask, and others were, it didn't matter if it was the day after your conviction, you could ask for a waiver. Probably would be unlikely to get it, but you could ask.
It seems to me, from my experience, especially with the example I gave some time ago, in a situation where the employer is well aware after a background check and would like this person to be employed, and unless the Department of Health has a good reason, and John Gotti and his organized crime family probably would be barred. But maybe Department of Health could have some oversight with regard to whether or not the employing agency, the nursing home, for example. I'm familiar with nursing homes. In my district, I chaired the board of Virginia Lutheran Homes that built the Brandon Oaks Retirement Community as an example, and well aware of the economics of nursing homes and so forth. That unless there's some overriding reason, the Department of Health says no, and the employer says we still would like to have somebody, unless the Department of Health says no, as long as the employer is well aware, it seems to me there ought to be a waiver system in almost every case. In your example, did you have a situation where the Department of Health could override the decision of the employer?
You mean presently with the laws the way it is today, Mr. Chairman?
The proposal. I think right.
So with the options from that CMS had outlined. So in that instance, the employer would not be able to hire a person unless they secured the waiver or the variance. So if the employer had gone through the process, discovered, was fully informed of the whatever crimes were on in the person's background, at that point they would have to request the waiver. There are certain rehabilitation factors that the state agency would have to look at, and then render its decision based on the weighing of those factors.
Right.
That's how CMS had structured it. It was not an automatic ability to hire, unless they of course had passed out whatever the minimum disqualification time period was, in which case.
But there would be a waiver process in every case of the recommendations.
There would be a waiver process if it depends on it. Forgive me, Mr. Chairman. It depends on which option that they picked. If it was an option where there's a minimum disqualification time period and you couldn't ask for the waiver until afterwards, then yes, in all cases you'd have to ask for a waiver. If there's a minimum disqualification period, but you could ask for it at any time, the only time you would need the waiver is during that minimum disqualification period. So I'll give the example of what's going on right now, where you have to wait 5 years for a single misdemeanor. If you adopted one of the CMS options that allowed for you to ask for that waiver during that 5-year time period, you could hire someone, if given the waiver, at let's say 3 years out from conviction. But if you didn't get the waiver from, let's say, the Virginia Department of Health in this situation, you could just wait 2 more years and then hire them at that point, because the minimum disqualification period would have elapsed.
So that's current law, or that's one of the suggestions?
That's a suggestion from CMS. That is one of the options that CMS looked at. Right now, Department of Health has zero discretion. Either they meet the criteria of that 5-year single misdemeanor, no abuse and neglect, or they don't, and it's a permanent bar to employment in these settings.
That's very helpful. Anybody, any further questions?
Yes, Mr. Chair, can you hear me?
Yeah, Delegate Price.
Okay.
Go ahead. Delegate Price, go ahead. Can you hear me?
Delegate Price, it seems like your microphone is cutting in and out. We can see you talking, but it might not be picking up anything.
Go ahead. Delegate Price, can you hear?
It looks like she's taking just a moment to take a look at her audio configuration.
Is Delegate Price still having troubles?
I believe so, Mr. Chair.
Mr. Chair, I think she reset her internet and will be back momentarily.
Okay. Wait. Anybody else, meanwhile, have any questions or comments?
Yes, I'm sorry, Mr. Chair. This is Sia.
Right.
Yeah. So I just wanted to see for any of the folks that answered any of our questions that said we don't currently get that data, what were the possibilities for starting to get the data? Because I know that once we can measure something, we can best know how to fix it. So what were the possibilities from each of the three groups on adding demographic data to something that could be obtained?
Mr. Chairman, if I may.
Yes, go ahead, Rebecca.
All right. Mr. Chairman, Delegate Price, for VDH, right now, all of our licensing processes are completely manual, by which I mean people they download Word documents, fill out paper applications, mail them in with paper checks. So for us to, and like I said, we're not a part of the background check process right now because of the way the statute's written. It actually says they have to go straight to VSP, the Virginia State Police, excuse me, to get those background checks. They have to go through VSP's portal to do that. So because we are fully manual at this point, which would require quite an investment to be even somewhat automated and be able to be engaged in data collection, and it would require a change to the statute. That is the barrier that we currently face. The only other way that I could foreseeably come up with to check on this sort of data would be every time we go and do the inspections is to record and bring back the results that are in the personnel files. But as I mentioned, right now we just do random pulls of personnel files. So we're not, we're not looking at every personnel file that a facility may have. So that may not give us complete data, but it's a possibility, but for VDH's purposes, it would require some significant changes to our infrastructure and would require a statutory change.
Delegate Mullen.
Thank you, Mr. Chair. Mr. Chair, a question for Ms. Allen.
Go ahead.
Thank you, Mr. Chair. Ms. Allen, we sit in these meetings almost every day and hear about IT infrastructure and about how we don't have the capacity, and that is an ongoing issue throughout the Commonwealth. But you said something that piqued my interest or terrified me, which is that there is a statutory bar to you being able to collect that information. Do you have a code section or an administrative area that I can look? Because we are always going to have IT infrastructure issues. But, you know, the money committees are always going to be the ones who handle these things. We are not a money committee right now, but we can definitely handle things that are in the code. And so this might be the right place for us to be able to focus on making changes to the code that are barriers to you being able to do your work.
Mr. Chairman, Delegate Mullen.
Go ahead, Rebecca.
In response to his question about what the statutory barriers are, so there's, I believe there's two code sections to look at. One is for nursing homes. The other one is for our home health and hospice piece. So for nursing homes, it is section 32.1-126.01. And I believe it is subsection A. Yes. So, and subsection A is kind of long. It's the third paragraph in subsection A. It says a nursing home shall, within 30 days of employment, obtain for any compensated employees an original criminal record clearance with respect to convictions for offenses specified in this section, or an original criminal record from the Central Criminal Records Exchange. The Central Criminal Records Exchange is Virginia State Police, so they have to get it from them. And then for the home health and hospice folks, that exact same language pops up again, and their section of code is section 32.1-162.9:1. And it is also.
Sorry, Alan, can you repeat that? I'm partially deaf in my left ear.
Oh, of course. Sorry. So it is 32.1-162.9:1, subsection A, and I believe it's the fourth paragraph within subsection A, and that's for your hospice and home health.
So is it your position that because it requires an original document that it has to be a Word document that's then printed out? Is that what you're?
Oh no, I'm sorry. The original document piece, when they're talking about original criminal record clearance or original criminal record history, that original document has to come from Central Criminal Records Exchange, which is the Virginia State Police. So it has to be the original document from VSP. And it's my understanding that when a facility first is stood up, first gets licensed, those sorts of requests have to come in on paper forms to VSP. But once they are in the system, so to speak, VSP will allow them to create an electronic account to be able to request those records and get them back more quickly. But they have to have that original documentation, whether it's they got it paper from the Virginia State Police or if it's they got it electronically through VSP's portal. That's what we're looking for when we're looking at their personnel files.
Mr. Chair, one quick follow-up because I know we're running out of time. Ms. Allen, I know we're running out of time. Maybe you and I can talk offline about that process because it seems like that needs to be streamlined and there's no reason that needs to be as difficult for you as it is. So,
Mullen, you'd be the perfect person since you're an assistant Commonwealth's attorney.
Oh God, I'm so sorry.
You know how to deal with these
anyway,
things.
Ms. Allen, I'm going to speak with the other Ms. Allen who's in my office, and maybe we can talk offline sometime this week.
Of course, that sounds wonderful.
Yeah. Sorry.
Mr. Chair.
Yes. Who's this?
It's Gina.
Gina Berger.
Yes,
okay.
yes. Yeah, it occurred to me when she said that, though, that maybe we should ask Virginia State Police, since they have the database, if they have data on demographics of people that are denied.
I would think they do. Mr. Chair, I'm interested in why the process is breaking down more than anything.
Okay.
And Mr. Chair, I'm interested in the data as well. So, because I was going to see if VDSS and DBHDS could answer the same question that VDH did about if you don't have the demographic data, would it be possible to get it? Are you all experiencing those same types of technical issues or systems problems, or is that something that you could implement?
Yeah, definitely. So we're in the process of the General Assembly gave us money. Thank you for our new adult and child care licensing system in this most recent General Assembly session. And so we will be collecting data in the future. We just don't have a comprehensive system to do that now. And then we are pursuing funding for a new comprehensive child welfare information system, what's commonly called CWIS, and would be able to collect a lot more data. So unfortunately, we're the only state in the country where all of our 4E foster care, everything is also on paper. So we are pursuing, an information system for our child welfare system, and we would look towards collecting better data in that as well.
Okay. Any further questions?
Mr. Chairman, this is Stacy Pendleton at DBHDS. So actually, like, the state police would not be able to help us necessarily, because we actually make the determination in-house. It's not the state police screening for us. They provide us the information. Some of that demographic information is collected by the third party who is doing the backgrounds, FieldPrint, that company, because that information is important when you're running the background. However, it doesn't make it into our system. We're just looking at whether they're eligible or not. So we will have to go back as well and look at our system to see if it's strictly an IT issue or if it's a process issue on collecting that data, because not the same information is actually coming to us when we're not actually doing the fingerprinting. We used to get a card and scan it and all of that. Now it's done at that third party. So Delegate Price will definitely look at that and can get back to the committee.
Okay. Any further questions? Yeah, Delegate Price.
I was just saying thank you, sir.
Any further questions? Any further comments? Okay, we're ready to move on to public comment.
Yes, Mr. Chair. It looks like there's 2 people in the waiting room ready for public comment.
Okay.
The first will be Debbie Taylor.
Okay,
I am promoting her in presently.
Okay, Debbie Taylor of Arlington. Welcome. Debbie Taylor, you're up.
Ms. Taylor, you can unmute yourself and go ahead.
I need to unmute and start video, right?
That's right.
Go ahead.
Okay, so sorry. Thank you so much, Chairman Edwards. My name is Debbie Taylor. I'm the president and CEO of National Capital Treatment and Recovery. Many of you will know me because I've been around for years. The name was Vanguard, then it was Phoenix. I worked with you, Chairman Edwards, on this issue when it first came to the General Assembly. My bias, and I must say, I run substance abuse treatment programs as I was opposed to this being enforced on substance treatment programs because there was not a record that there had been an issue before. When I was involved in the hearings early on, it was very clear that the law was designed to protect those individuals who were most vulnerable, which I totally support, those in nursing homes, those in child care centers. And my folks, I have to say, are generally not vulnerable. I was concerned that we were not exempted the way that hospitals and correction facilities were. And if I could wave a magic wand, which I know I can't, and it's very naive, I would like to go back to that. The reason being is that so many of our folks, which you have stated, and Ms. Pendleton has stated, that are in recovery and are needed in our workforce, especially now. I turn away many, many, many people of color. And the numbers that you have for rejections, I believe, pale to the number of people who don't even get to your system because we pre-screen them and essentially say, if you have a felony, forget it, unless you're willing to go through a screening process. And most of those individuals were charged with crimes that were much more severe back then. And I know you're looking at some of that in the whole criminal justice reform. So they have felony convictions then that may not be considered a felony today. Many of them went to jail. The majority of the people that were convicted were of color. I am not able to hire the workforce that I need. And rather than this being a barrier system to protect my patients, it is a barrier crime for me to allow individuals who have gotten their lives back together to be gainfully employed and to give back to the community. One of the other things is that on the screeners, I think we need more screeners if we're going to do this, and we need more publicity about how you become a screener. I mentioned the point about hospitals and corrections. I don't understand why hospitals are exempt and I'm not. I would like to have the epidemic be looked at as a cause, almost from an emergency measure, to be able to provide people. I have an individual who would be willing to come and talk, who was a federal criminal, very large crime. I hired him before these barrier crimes existed. He had 10 years in recovery. He subsequently retired and therefore lost his grandfathering in. He was totally forgiven all his crimes by the governor, but yet I can't employ him because of his very serious crimes that are now 30 years old. And he is one of the most terrific advocates for recovery that we need. So if we want to stop this drug epidemic, we need to allow people who are capable of working with our population and not put barriers to that. I do understand that there are certain crimes and predators that you do not want in the workplace, but we have really got to open it up, especially for substance use disorder license programs in Virginia. Thank you very much. As you can tell, I'm very passionate about this. I've been in this field for 50 years. The best folks that I have working for me are people that would be exempted from hiring had they not come to me before this legislation was put in place. So thank you very much.
Thank you, Debbie. Thank you for your comments, and I agree with you 100%, and I appreciate your support for what we're trying to do. Any questions? Any further comments? Debbie, thank you so much, and I hope you can keep up with us and keep us informed and help us along the way as we hopefully get some good legislation drafted.
Our next speaker is Melinda Roberts. I'm promoting her in presently.
Linda Roberts?
Melinda Roberts, pardon me, Mr. Chair.
Roberts, okay. I don't have her down. Melinda Roberts. Is she here?
Yep. Ms. Roberts, you're welcome to unmute yourself and go on ahead. Ms. Roberts, are you there? Mr. Chair, she may have stepped away from, oh, pardon me. It looks like she just.
I apologize. I was just listening. I did not wish to comment.
Pardon me, Ms. Roberts. No worries.
Okay, listener. Okay, who's next?
Mr. Chair, that concludes all the people presently in the queue for public comment.
Sherry Neal and Brian Eno are not available?
That is correct, Mr. Chair. They haven't arrived into the meeting.
Okay, if anybody publicly would like to send something by email to DLS or anyone on the committee or commission, you're welcome to do so. Okay. Having no further public comments, discussion among members. Any comments? Sia? Delegate Price, any comments?
I do. Delegate Mullen had his hand up first. I'll let him go on.
Delegate Mullen.
No. I'm never going to be the one to interrupt Delegate Price. She's the vice chair for a reason.
There you go.
So I just wanted to make sure with Sabrina and the staff that we work very closely with, I want to make sure that I understand what we're doing in between each meeting. And so if, and I've seen you taking copious notes, and I think we're both definitely in tune with that. But I just, for the public's benefit, we don't just listen to this information and do nothing with it. We have a work plan. We're going to continue. But what should the members be doing between this meeting and our next meeting?
Okay, any comments? Delegate Mullen? I'm sure you have a comment.
Oh, I have two, Mr. Chair. First, it was raised by myself and Senator Serval last meeting, and I know it wasn't quite addressed because it might be outside of the scope of this committee, although I hope it is not. That while it is not explicitly a barrier crime issue, is certainly a barrier and an ancillary issue to many convictions, which is the immigration consequences of a conviction, even for misdemeanor convictions here in Virginia. I hope that it would be the work of this group over the course of the rest of the year that we also consider some of the immigration consequences. I know that there have been bills in the past that have been referred to this group talking about misdemeanor convictions at 364 days as opposed to 365. I think that that is always something that we should be thinking about. I'm not sure whether or not, Mr. Chair, that's something I know that that is something that has been a pet project of Senator Serval for a long time. So I wanted to make sure that I raised that. And then second, I know that it is also something that I have raised before, which is thank goodness for the attorneys and staff who have put together so many of the wonderful materials that we have before us. So I want to thank you for it. One of the things that I learned from it is that the barrier crimes statutes and requirements that we have are so disparate throughout the code, particularly through 18.2 and 19.2, that it is almost impossible to be able to figure out where to find them. And so my hope is that independent of the substantive policy work that we do from this group, that we can rely on some of the great legal minds that are working with us to be able to coalesce all of the barrier crimes requirements that we have into one substantive section. I'm going to guess that, Mr. Chair, that's probably going to be a 19.2, but I don't know where that would best be put. Mr. Chair, this is yours. So I would defer to you or staff better than anything else. But my hope is that when we're all done with this, that we have a central place to look in the code for all the requirements of barrier crimes, all the requirements that we have for where we can look for appellate rights, for what the statutory requirements are going to be related to barrier crimes.
Any further comments? Yeah, I agree, Delegate Mullen. That's why I started out with Senate Bill 831 in 2015. Little bill of 61 pages and 3,708 lines that was pulling together, because it is all over the code. It needs to be in one spot with all these situations. And I would hope also we could look at limiting the Department of Social Services barrier crimes to what the federal government requires. The others, behavioral health and developmental services and Department of Health, don't have any federal mandates, as I understand it. And we need to look at other states and see what they're doing. It's very important too, as we just heard from Debbie Taylor, that we take into consideration the burden on the Department of Social Services for people who cannot have these jobs, when it would be helpful for them, their life experiences to be helpful to people who are to the welfare of society, and also to make sure that it's another burden on DSS when people don't have jobs. So I think we're losing a real opportunity to have barriers again for some people. And I would hope we'd also look at why not with regard to behavioral health and developmental services and Department of Health to limit the number of barrier crimes, and like with social services as well, but limit the number of barrier crimes to those that we actually need and not have misdemeanors necessarily, and have an appeals process that's an expeditious appeals process. I think that's extremely important. But those are my overview comments, and I'll be talking to legislative services as we go forward to maybe look at some further directions. Any further comments? So the next meeting is, when's the next meeting for this commission? Or something?
Chair, we have not yet polled for the next meeting yet, so we can talk about getting that together and sending a poll out to members.
We have to complete by November sometime, is that right?
Mr. Chair, yes, sir. We have to complete our meetings by November 30th.
You want to have a meeting next month, July? We have 4 meetings, is that right?
Mr. Chair, yes, sir. Yeah, we can certainly poll. I'll let Sean can elaborate a little bit more about polling, but there's no reason why we can't poll for to have a meeting next month.
Okay. All right.
Certainly, Mr. Chair, just send me over the dates that you're interested in looking at and be happy to send that poll out.
Okay, that'd be good. Okay. Any further questions? Delegate Bagby, any comments? Delegate Price? Delegate Mullen?
No, I don't have anything, Mr. Chair.
Okay. Okay. Any comments from Gina Berger? Okay. Any comments from Rebecca? Okay. Any comments from Stacy Pendleton?
Mr. Chair, this is Thea. Just want to make sure for the information that was presented today, if we have not already received it, if we could, that would be really amazing. Thank you.
Yeah, I agree. Okay. Well, appreciate the good work you are doing. I hope we can whittle this thing down to something manageable. It's extremely important. Okay. Well, Sean will get in touch with us for a date coming up, hopefully in next month, and then we'll go from there. Okay. Thank you all very much. Without, is there a motion to adjourn? Yeah, Delegate Mullen?
So moved.
Okay.
Second.
Delegate Price seconds the motion. All in favor of the motion, say aye.
Aye.
Aye. All opposed, no. Motion carries. Thank you all very much. Appreciate it.